What can a father do if, after the divorce, the mother who was awarded custody of the child is turning the child against the father? What can he do? Well, there are many things he can do, many of which improve nothing and often make matters worse. The better questions are, 1, what should he do? And 2, what can he likely do successfully? All right, number 1, what should he do? Determine whether, in fact, it is the mother who is turning the child against him. If so, start immediately to document as fully and extensively as possible the mother's wrongful actions that are turning the child against him. Do not fight fire with fire. Do not take his frustrations out on the child. Consult a good meaning a sane, decent, and skilled, in that order, mental health therapist or counselor about how best to deal with the situation so that the father does not inadvertently make things worse in his efforts to make things better. All therapists and counselors are not created equal. Buyer beware. Many counselors and therapists suffer from mental health problems themselves to the point that it interferes with their abilities to do their jobs objectively and responsibly and competently. The market is flooded with counselors and therapists of vastly varying quality, and so a good portion of them are desperate for money. Those are the ones who will say and do anything to get father to spend his money on them, and because they have at least some education and training in understanding human nature, they know how to manipulate people. Be very careful in how he gets his mental and emotional health advice and from whom he receives it. Consult a good family lawyer so that he knows how to prepare and proceed in a legally permissible and evidentially sound way. The problems he will encounter in finding a good family lawyer are all but identical to those he will encounter in his search for a good mental health therapist or counselor. So he needs to choose carefully. He needs to take his time. He should interview not just 3 or 4 lawyers, but 5 to 10. I know that's a lot of work and time, but it's worth it, trust me. He can't get a feel for who the mediocre and incompetent lawyers are without surveying a large sample. Don't try to win a parental popularity contest. Just be the good father the child needs. The child will appreciate that even if the child isn't consciously aware of it at the time. Be the parent the child needs him to be. If he makes it his mission in life to defeat the parental alienator, he will get distracted from what he can do best for his child. Ask the mother why she is turning the child against him. Try to work with the mother to resolve any ill will or disputes that are behind her actions so that they stop. 2. If the mother will not voluntarily stop alienating the child, what can the father likely do successfully? Well, if he can, legally, lawfully, and morally solve the problem without litigation, do it. Going to court for solutions to parental alienation problems can be and often is more trouble than it is worth. But there are plenty of times when the father has no other viable option than trying his luck in court. Before he decided to pursue the matter in court, he needs to know first that if the evidence of parental alienation is not ample and strong enough to persuade the court, the father needs to accept the fact that he can't obtain relief in court, or at least the odds are highly against him. Second, he needs to know that even if he has a strong case, that he persuades the court that the mother is alienating the child and obtains court orders intended to help put a stop to the parental alienation, some mothers won't let any of that stop them. Many parents are understandably stunned to learn the difference between a mere court order and the enforcement or enforceability of court orders. A court order is meaningless if the court won't enforce those orders when a parent disobeys them. And many court orders in child custody and divorce proceedings go unenforced. And this is for 4 main reasons, in my view. 1, the courts and jails are overwhelmed, so if they have to choose between putting a burglar or a parental alienator in jail, the burglar gets the bunk. Number 2, courts are reluctant to impose harsh penalties on parents, particularly mothers, and so if a non-compliant parent calls a court's bluff, the court will often blink. Number 3, imposing fines and awarding attorney's fees are often pointless because if the parent does not pay them, few courts are willing to jail a parent for failing or refusing to do so. And 4, extreme measures such as modifying the child custody and parent time awards to shield the child from the alienating parent are hard to justify when courts, justifiably, worry whether that will only harm the child more. If the father takes the matter to court, he and his attorney need, first, to be convinced that they have or can make not simply a good, solid case for proving parental alienation, but an overwhelmingly solid case, and to have a proposal for relief that a court can believe in and get behind, one that a court is persuaded will work, meaning that it will not make matters worse for the child than they already are. What does such a winning case consist of? First and foremost, objectively verifiable proof. Proof that the mother's actions serve no legitimate purpose, clearly will cause, if they are not already causing, the child harm, whether that be physical, psychological, and/or emotional harm. They need truly competent and impartial expert witnesses whose findings, analyses, and opinions hold up under scrutiny. If the father's attorney claims to have a hired gun who he or she says can get away with anything that the father needs to say to win, that would not only be unethical and illegal, but risky as well. Briefly, what am I suggesting as far as proof? This is a summary and not an exhaustive list that follows, but it should give a father a good idea of what he needs to show. Direct evidence of alienating behavior, explicit actions and communications, things like text messages, emails, or recordings where one parent actively denigrates the other in front of or to the child. Witness testimony, statements from teachers, counselors, court-appointed guardian, or custody evaluator, or other neutral third parties confirming the alienating parent's negative influence on the child. Expert testimony, psychological evaluations showing signs of undue influence or indoctrination by one parent. Child's behavior and emotional responses, proof of sudden and extreme rejection. If the child once had a healthy relationship with one parent but now refuses contact without a valid reason, this may indicate manipulation. Use of adult-like language by the child. When a child speaks about a custody issue or issues using sophisticated adult-level legal language, it suggests coaching. Lack of ambivalence. If the child sees one parent as entirely good and the other as entirely bad, it suggests possible programming and coaching. 3, interference with parent time and communication, consistent violation of court orders, repeated refusal to follow visitation schedules, blocking communication, evidence that one parent intercepts calls, messages, or prevents the child from speaking or writing to the other parent, false allegations against the other parent. If a parent has made multiple unsubstantiated allegations, for example, of abuse or neglect, that are later disproven, it suggests an attempt to alienate the child from the other parent. The parent's actions and motives. Encouraging the child's autonomy selectively. A parent who says, "I left the child to decide whether to see his father or mother, or when the court has ordered visitation," may be subtly alienating. Reinforcing fear or negative perceptions. If the alienating parent exaggerates minor incidents or portrays the other parent as dangerous without cause. The child's preference. Analyzed objectively, while a child's preference is relevant, I would carefully consider whether that preference is freely formed or the result of coercion or manipulation. Efforts at reunification and parental cooperation. If one parent is making documented efforts, for example, therapy, family counseling, and other such things, to rebuild the relationship while the other parent obstructs those efforts, it can indicate alienation. Proving and remedying parental alienation is not easy, inexpensive, or something you can have get through court quickly. Be prepared. Forewarned is forearmed.